If it please the court, Your Honor, my name is Yu Jiazhang, and I will appear on behalf of the defendant, Mr. Featherstone. Your Honor, under Section 398 of the Criminal Code Act 1899, Queensland, the maximum penalty for stealing is 5 years imprisonment. In this case, because Mr. Featherstone stole some high-end car audio equipment from his employer, and the value of the stolen exceeded $5,000. This case is likely to fall under Special Case 6 and Special Case 9 of Section 398 of the Code. The court could sentence Mr. Featherstone to 10 years imprisonment. The defense will seek a lighter sentence than 10 years detention, taking into account Mr. Featherstone's early plea guilty and remorse for breaching his community service order, as well as his age and physical and mental condition. The defense will submit that the actual period of detention is unnecessary, given the circumstances surrounding the incident, and that a non-custodial sentence is more appropriate. Your Honor, I would like first to address Section 13 of the Penalty and Sentence Act 1992, Queensland, hereafter referred to as the PSA. This section makes it clear that a guilty plea is an important mitigating factor in determining punishment. Analogy with the crime against parole, Mr. Featherstone pleaded guilty at an early stage of his conviction for stealing, and such a plea could be seen as evidence of remorse. Furthermore, Mr. Featherstone's early guilty plea facilitates the justice of the system by saving the cost of a trial and reducing the need for his employer to provide evidence. Your Honor, I would now like to draw your attention to Section 9, subsection 2F of the PSA. This section stated that the age of the offender is one of the factors that the court must take into account when imposing a sentence. The Queensland Court of Appeal in the crime against Hammond noted that youth is also a mitigating factor relative to the seriousness of the offense and the previous conviction. Your Honor, Mr. Featherstone's immature age and moral development were relevant to his stealing conduct. This is because it never occurred to Mr. Featherstone that taking some of his employer's car audio equipment was stealing until the court proceeding. He had no intention of selling or profiting from the equipment. Further, Mr. Featherstone accepted responsibility for his action. I therefore find that Mr. Featherstone should receive a reduced sentence. Your Honor, the character of the offender is another factor to be considered by the court when sentencing. Under Section 11 of the PSA, in determining the character of an offender, the number of previous convictions, the severity, and any significant contribution made by the offender to the community are assessed. In the trial against the Queen, the court stated that, firstly, it must be determined whether the offender is otherwise of good character, and secondly, if the prisoner is of good character, the sentencing judge must take this fact into account. In this case, Mr. Featherstone had 6 previous convictions, the most serious of which was for operating a vehicle dangerously while participating in an illegal race. And the conviction was satisfactorily complete. Mr. Featherstone is a young man who had made mistakes in the past, but is eager to change his life. He currently has a stable job, and his employer has provided a reference indicating that he is a valuable employee. If Mr. Featherstone is imprisoned at this time, he will lose his current stable job. Your Honor, I I would next like to draw your attention to Section 9, subsection 2G of the PSA, where the physical condition of the offender is a mitigating factor in the imposition of sentence. According to the Crown against the case of the Crown against Smith, the judge noted that ill health would only be a mitigating factor if imprisonment would impact a greater burden on the offender's state of health. In the case of Ellington, the court held that mental abnormality is a factor in promoting criminal behavior. Your Honor, there is no doubt that both Mr. Featherstone fully understand the order at the sentence hearing due to severe migraines, and his general practitioner's email showed Mr. Featherstone was a borderline alcoholic who also suffered from chronic depression. At the time of compliance with the community service order, alcoholism and depression induced mental abnormalities, made it difficult for him to attend scheduled community service sessions. Imprisonment will affect Mr. Featherstone's ability to receive timely treatment. This could have a serious adverse impact on his health. Your Honor, although the duration of imprisonment is always within the range for the offense of stealing, I submit that the actual imprisonment in this circumstance would serve no useful purpose. In the Crown against Marcinic, the court held that progress in rehabilitation was more important than the principle of deterrence. Because of Mr. Featherstone's relative youth and his acknowledgement of his wrongdoing, he has found new and stable employment and is receiving counseling for his health problem. If a detention order is made, Mr. Featherstone's work and treatment of his health will be affected, which could influence Mr. Featherstone's future prospects. The court could resentence Mr. Featherstone to another community service order with conditions of compliance with medication and regular counseling. Unless there are anything further, Your Honor, that concludes my submission in respect of sentence. Thank you.